Hello, my name is Joshua Gilliland and welcome to another installment of the Legal Geeks educational series. Today we will be discussing expert written reports. Disclosing experts and the timing of their reports and what can be disclosed and what cannot be disclosed is always very exciting in civil litigation, either in federal court or state court. When a witness is disclosed, a written report must be included with that disclosure if the witness is retained or specially employed to provide expert testimony in the case, or whose duties as the party's employee regularly involve giving expert testimony. What must be included in an expert report are the statements of all the opinions the witness will express and the basis for each of them, the facts or data considered by the witness informing the opinions, any exhibits that will be used to summarize or support them, the witness's qualifications, including a list of all publications authored in the previous 10 years, a list of all cases in which the previous 4 years the witness has testified as an expert at trial or deposition, and a statement of the compensation to be paid for the study and testimony in the case. As we look further into the rules, there are additional rules pertaining to experts. Specifically, the deposition of an expert who will testify at trial. A party may depose any person who has been identified as an expert whose opinions may be presented at trial. Pursuant to Federal Rule of Civil Procedure, Rule 26A-2B requires a report from that expert, and the deposition of said expert must be or may be conducted only after the report is provided. Additionally, we have rules pertaining to trial, preparation, protection for draft reports or disclosures. Pursuant to Rule 26B3A and B, protects drafts of any report or disclosure required under Rule 26A2, regardless of the form in which the draft is recorded. So what's this mean? Well, when we look at trial preparation and protection for communications between a party's attorney and expert, this was always a sticky issue, when I was practicing actively, because there were issues of any email going back and forth with your expert that could be produced. So, what can and cannot be produced? Well, pursuant to the rules, Rule 26B3A and B protect communications between the party's attorney and any witness required to provide a report under Rule 26A-2B, regardless of the form of communications, except to the extent that the communications relate to compensation for the study or testimony, or identify facts or data that the party's attorney provided and that expert considered informing the opinions to be expressed, or identifies assumptions that the party provided and that the expert relied on informing the opinions to be expressed. So that concludes our overview of written reports for expert witnesses. Be sure to tune in again for more information on the Legal Geeks. Thank you.